In this video, I will be discussing invasive knotweed and legal liability. This is part 2 of a 3-part series. It focuses on property transactions. In part 1 of this series, I looked at legal developments in the United Kingdom, where knotweed has been a societal, political, and legal concern for decades. In part 2, this presentation, I'll talk about real estate transactions, mainly home sales in the United States, and how they might be affected by the presence of invasive knotweed. In part 3, I'll look at nuisance and tort actions, primarily instances where a knotweed infestation from one person's property encroaches on another person's property. This presentation includes a number of legal citations. The full citations are available in the written description for this video. The only legal case in the entire U.S. that concerns invasive knotweed and property transactions is Trites v. Cricones, a case from Massachusetts. This case involves the sale of a new home by a developer, Cricones, to the Trites family. The Trites bought the house in the winter and were able to inspect it only after the lawn had been hydroseeded. In the spring, invasive knotweed started coming up and other problems arose. The Trites sued Cricones and his development company under a number of different theories. After a trial, the court found Cricones knew about the knotweed, knew it was problematic, and failed to disclose its presence to the Trites. The trial court awarded the Trites $186,000 in damages and also awarded them attorney's fees under a Massachusetts consumer law. The Court of Appeals affirmed the judgment in February of 2025. In assessing the potential liability exposure in a case like the Trites case, context is very important. The invasive knotweed in that case came from loam that was piled or brought into the housing development. That loam may have been placed onto many more lots than the one bought by the Trites. The liability exposure, therefore, could have been multiplied by 27 times. How does the Trites case fit within the nationwide landscape of residential real estate law? It is important to remember that the Trites case was decided under a state consumer law. The outcome could be different in other states which do not have consumer laws that are as far-reaching as the one in Massachusetts. Generally, the legal doctrines which govern home sales broadly fit within the 4 categories shown here. I have ordered them from the most stringent for the seller to the least stringent. However, as you shall see, this hierarchy is not ironclad. The warranty of habitability is one doctrine that governs home sales in some states. The warranty typically only applies to new homes. In its purest form, the warranty of habitability imposes strict liability. There is no question of whether the defect in question is obvious or hidden. There's also no question about the seller or the buyer's awareness of any defect. New Jersey was the first state to adopt a strict liability standard via court decision. California now has common law and statutory protections that make builders of new homes strictly liable for certain construction defects. There are a number of different definitions for the term material defect. This is one from the International Association of Home Inspectors Standards. The defect must have a, quote, significant adverse impact on the value of the property, close quote. In the Trites case, the appeals court applied an even stricter standard and required the plaintiffs to prove that they would not have bought the house had they known about the defect, i.e., the defect had to be a deal breaker. Is the presence of knotweed a material defect? Despite the effect of invasive knotweed on property values in the United Kingdom and the sizable awards in the 2 cases in the U.S., the answer to this question is not necessarily clear. Plaintiffs can certainly help their case of demonstrating that knotweed is a material defect by offering evidence of specific harm to the buyer's use and enjoyment of the property and the general harm to the value of the property. Would the warranty of habitability have protected the Trites family if that was the sole basis for their lawsuit? Probably not. That's because Massachusetts only applies the warranty of habitability to structures. Thus, although this warranty in many cases can create strict liability, that liability may only apply to the condition of the structures and could leave claimants for damages from a knotweed infestation out in the cold. This is one way in which a warranty of habitability is not as protective as one might expect. The Trites were fortunate that their lawyers were aware of the Massachusetts consumer law. The most common doctrine nationwide is the one that requires disclosure of known defects. In most states, this requirement applies whether the transaction involves a new or used home. One example is Minnesota. The Minnesota disclosure law requires the seller to identify all material facts of which the seller is aware that could adversely and significantly affect 1. An ordinary buyer's use and enjoyment of the property, or 2. Any intended use of the property of which the seller is aware. Interestingly, the Minnesota law does not look to the effect of a defect on property values, but instead looks to the use and enjoyment of the property by the purchaser. Here, plaintiffs might have to argue that the invasive knotweed affected their use and enjoyment of the property in at least 2 ways. First, it required them to work or pay for work to control the knotweed. Second, it affected their use and enjoyment because the knotweed potentially made the property harder to sell. Most states apply this standard to new or used homes. This is important because over 70% of home sales involve used homes. The requirement to disclose known defects, unlike the warranty of habitability, may also more likely extend beyond the physical structures on the property. There is not much reported case law on this issue. However, at least one law review article by Schisler contends that material defects to non-structural parts of the property may give rise to liability. In the article, Schisler specifically cites this as a potential advantage in those states not employing the warranty of habitability. Would the disclosure of known defects doctrine have protected the Trites family? Possibly. If Schisler is correct that the doctrine extends to non-structural parts of the property, that would be critical. The third doctrine requires the disclosure of hidden defects. A hidden defect is one which could not be discovered by reasonable and customary observation or inspection. This puts the added burden on the plaintiffs to prove an additional element, namely that the defect could not have been discovered by a reasonable and customary inspection. With invasive knotweed, this doctrine raises all sorts of questions as to how much protection it affords the buyer. In the Trites case, the appeals court found that the plaintiffs were not required to prove the defects were hidden. Nonetheless, the plaintiffs offered proof that the defects were in fact hidden. The inspector testified that it was not customary to inspect for invasive knotweed. Moreover, the inspection was conducted in winter after the lawn had been hydroseeded. What if the invasive knotweed was actively growing and could have been seen by a buyer or inspector? Under normal circumstances, a defect which is visible would be patent or obvious. However, a plaintiff could argue that because invasive knotweed is not a well-recognized threat in the U.S., the presence of it is not a defect which could be, quote, discoverable by reasonable and customary observation or inspection. The final doctrine is caveat emptor, or buyer beware. While there is some question as to the degree of protection afforded by the other doctrines, there isn't with caveat emptor. Surprisingly, Massachusetts is one state which applies this standard. Thus, in the Swinton case from 1942, a home seller was found not liable for the failure to disclose a known termite infestation. Why didn't the caveat emptor standard get applied in the Trites case? The seller in that case was a professional developer. This was new construction, and for those reasons, the Massachusetts consumer law applied. Would the caveat emptor doctrine have protected the Trites family? Almost certainly not. There is one exception to caveat emptor. If a seller actively conceals a defect, this can constitute fraud, which is a known exception to the caveat emptor doctrine. This has to be more than mere silence. In Striplin, a New York case, the seller covered rotted wood with new wood to hide water infiltration. In Trites, there was no evidence of fraud. Regardless which state you live in, there are some general guidelines to follow. If you are a seller, the advice is pretty simple. Control any knotweed on your property, disclose its existence. Finally, don't try to hide the knotweed. No matter which state you live in, that is one way you could heighten the risk of liability. If you are a buyer, be aware that the seller may not know what invasive knotweed is. Most inspectors will not look for it or know what it is. Your real estate agent and any lawyer you hire will also likely not know what it is. This places a burden on you to be educated. This means if you have any concerns, ask the seller. If you are in an area with heavy infestations, you should ask your attorney or other advisor about getting written assurances. Finally, you or someone you hire should do a thorough inspection. You likely will be the one person with the most information about invasive knotweed. Even if it's winter, there may be evidence of an infestation. For example, there may be the telltale dead stems. That's it. In the last part of this series, part 3, we'll address nuisance and tort actions.